Okay, we're back on the record.
Thank you. Okay, so Dr. Milburn, when we left off, we were talking about overlooked negative information about the mother. Do you recall that?
Yes.
Okay, and you had indicated that the father had represented to you that he had attempted to give information to Ms. Frendel that she did not receive or did not accept. Is that correct?
Yes.
Okay. And upon your review of the report, you did not, you were not aware of whether or not Ms. Frendel actually reviewed that information or not. Is that correct?
Only based on what was listed in her report.
Okay. And can you tell me specifically, I think this is kind of our last question, what did the father indicate he had given to Ms. Frendel that she would not accept and review?
I don't specifically recall.
Okay. Can you give me some idea of the topics that he indicated that he had told Ms. Frendel about that she disregarded?
I think one of the topics was about the incident, the accident that happened in 2013 with the car. I think one of the topics had to do with his work and the child starting a podcast and whether or not the child was enjoying doing well at that. And I know that was something that I definitely reviewed. I looked at the child's podcast. I looked at how the child was doing on there and whether there was any anxiety or not. And off the top of my head, that's the best that I can think of.
Okay. I'm going to skip for a second because let me just ask you, what materials has the father provided to you to review in this case?
He has, and there's a list in there for you to be able to see so you know what I looked at. On page 3 of the report dated January 7th, 2020 of expert opinion report, it gives the material that I reviewed. And then it lets you know when I talked to the dad and he signed up policies and procedures and all for the court. And then in the updated opinion that was requested, it also gives a list of material reviewed.
And when did you generate an updated report?
October 27th of 2021.
And why did you generate an updated report on October 27th of 2021?
The father's current attorneys stated that they were going to call me as an expert and needed to designate me as an expert regarding parental alienation.
Okay.
And they asked me to look at the material and to give an opinion.
So just so I'm clear, you're now under the impression that you are designated as both a rebuttal witness for the child custody evaluation and as an expert on parental alienation.
I believe that's what Ms. McKnight designated me for. Well, let me back up. I haven't read any court documents, so I don't know if they designated me properly with the court or not. I know that when Ms. McKnight hired me to look at this case, she hired me to look at Ms. Frendel's report, to offer an expert opinion on it, and to be available as a witness regarding parental alienation and child abuse and child custody evaluations and ethical guidelines and the limitations of roles for professionals involved in family law litigation. And in that area that Ms. McKnight hired me in. The question of parental alienation is one that the father's current attorneys contacted me and clarified that they were going to designate me as an expert to testify to that.
Okay.
And to render opinions regarding the nature of the relationship difficulties between the father and the minor child as of 2021.
All right. What professional training have you had in the area of parental alienation?
In my training, beginning all the way back at the time in UT Southwestern Medical School, I had extensive training in parent-child relationships, parental alienation, child mental health diagnoses. I conducted my first child custody evaluation while I was an internship student at Scottish Rite Hospital under the assistant director of the department of the university in the field of psychology. And it's been continued in my training, including the workshops that I attended back in 1998 in California with the College of Forensic Examiners. And part of our training involved looking at parental alienation and parent-child relationships. And that type of training has continued on. My most recent high conflict divorce training was in Louisiana, in Shreveport, Louisiana. I believe that was about 5 years ago, where the updated laws, parental alienation, dealing with high conflict divorce litigants, and health issues related to that were covered.
And what continuing education courses have you taken in the last 5 years that pertain to parental alienation?
In the last 5 years, actually in the last year, we're required to keep 20 hours of continuing education every year. So I'm up to date on that continuing education. The most recent classes that I had, aside from the required ethics, ethnicity, involved parent-child relationships, custody evaluation. There was and all the custody evaluations include parental alienation and looking at abuse versus alienation. And then the biggest one that I enjoyed quite a bit had to do with domestic violence.
And when
domestic violence in child custody litigation.
And again, my question was, in the last 5 years, what have you attended? What specific courses have you attended in the last 5 years that relate to parental alienation?
I'll have to pull out my file and I can give you the exact courses if you'd like me to send those to you. So let me do that. But I don't have those with me. I have to go to my other office.
And just to be clear, for the court's purposes, your continuing education courses are not listed on your CV. Is that correct?
That's correct.
Okay. But is it your testimony that you have attended courses dealing with parental alienation in the last 5 years?
Yes.
And is it your testimony that you attend those continuing education courses annually in the last 5 years?
Yes.
As far as research projects, have you published any articles on parental alienation?
No.
Have you had any clinical positions that deal specifically with identifying parental alienation?
All of my forensic court work, yes.
And when you mean forensic court work, you mean private practice work in conducting child custody evaluations?
Yes.
Have you ever held a position with a, I'll strike that. Have you ever testified before in terms of identifying parental alienation?
Yes.
How many times?
Probably more than 50.
And
with that being the specific focus of the testimony.
Understanding my question is, have you been retained as an expert specifically to identify and discuss the signs of parental alienation and not in the course of conducting a child custody evaluation?
No,
So you've never actually testified as an expert on just the topic of parental alienation, having not been also involved in the child custody evaluation being conducted?
that is correct.
Okay. Is that part of the reason that you met with Mr. Crockett prior to commencing your work in this case? Well, strike that. Let me ask it a different way. Did you know at the time that you met with Mr. Crockett in December of 2019 that you would be identified as an expert in parental alienation?
Yes,
Okay. So is that why you met with him in 2019 to develop his side of the case so that you could state an expert opinion on parental alienation?
I met with him in order to understand the background and the specifics of the case and the things he was concerned about and the things he was alleging. And also to make sure that he understood what my role was and that we didn't have any miscommunication or misunderstanding about what it was that I would be willing to do versus not willing to do.
Can you tell me what you told Mr. Crockett you would not be willing to do?
Yes.
What
I told him I would not be willing to make any specific recommendations regarding the child and access or possession of him or for the mother. I explained to him I have not evaluated the mother, and that even if I see indications that there's parental alienation on mother's side, if I also see indications that there's parental alienation on his side, that also would be something that I would testify to. And that without meeting with the mother and without meeting with the child, I cannot make and will not make any definitive statements regarding this mother or regarding the child. That's not my role. So that even if you have, I explained to him, even if you have a case where here you've got some pretty clear indications that it looks like, for example, it's parental alienation, I can explain to the court what parental alienation is, and I can explain to the court what I'm seeing that looks like it's occurring. But I am not testifying as an expert saying it is occurring in this case. I'm not seeing mom, I'm not seeing child, and it's not that kind of evaluation. So I wanted to make sure he understood.
And forgive me, I need to make sure I understand. So are you telling the court that you intend to discuss what parental alienation looks like and how it could present in a given relationship, but not specifically as it applies to this child, this father, and this mother?
Well, I think, again, as an attorney, you know, I'll be answering the questions that I'm asked. So an attorney, his attorney or you could ask, okay, look at this statement right here by the mother. Is that the kind of statement that a mother who may be prone to parental alienation might make? And my answer then would be yes. Let's say the example is yes. Yes, that's a statement that you might see that's consistent with somebody who is engaged in parental alienation. But if the attorney asks me the question, so are you saying this mother is engaged in parental alienation? My answer to that specific question is, I can't say that. Even if, like, mom has a deposition, some deposition answers that are consistent with someone who could be a parental alienator, I haven't evaluated her, and I will not testify that she is a parental alienator. I can tell the court what parental alienation is. I can tell the court what I think is consistent with parental alienation. I can testify to my concerns about the father and the child's relationship and where it is now. He's given me phone recordings to listen to, and I understand the child doesn't even want to talk to him on the phone at this point. So attorneys can ask me hypotheticals, they can ask me specifics, but in any case like this, I haven't evaluated the mother, I haven't evaluated or seen the child, and I don't have all the information, all the documentation in this case. I can tell you from what I'm asked and what I've seen, But I will not come in as somebody who's going to specifically say this is happening to this child for sure.
Okay. Why would you accept the position to testify as an expert regarding parental alienation in this case when you've never done it in the past?
I have testified about parental alienation as an expert in the past many times. I accepted that role in this case because when the attorney contacted me, when Ms. McKnight contacted me and wanted me to look at this and had concerns about that, I agreed to accept that role to look at that part of the picture and whether or not that might be occurring in this case.
Did you tell Ms. McKnight during that conversation that you had not been published or worked in this capacity as an expert previously, having not been in the course of a child custody evaluation?
Ms. McKnight has worked with me and known me for 30 years. She was one of the first people who had me on a child custody case that I was court appointed. So she knows my curriculum vitae, she knows my background, and she knows my expertise very well.
Objection, non-responsive. Did you tell Ms. McKnight that you had not testified as an expert on parental alienation in the past when you were not within the course of conducting a child custody evaluation?
No, I don't believe that was a conversation we had.
Okay. Kind of jumping back, when we left off with your list, we were talking about the negative information that you received. Your next one that you had mentioned was essentially her limitations you thought were insufficient. Is that correct? Miss Frendel's limitations were insufficient. Is that correct?
Are you referencing her 2-sentence statement about the information she didn't review or wait to get?
That's correct.
Okay.
And I believe you testified earlier that you thought that kind of catch-all CYA language was just insufficient. Is that correct?
I think it's insufficient in this case, yes.
Would you agree with me that you've reviewed child custody evaluators in the past that oftentimes use those kind of catch-all phrases?
I don't recall seeing a child custody evaluation that used that kind of a catch-all phrase that was connected with not getting mental health records from one of the parties or the child. I don't recall seeing that in any of the cases I've reviewed.
And all of the time, well, the 6 occasions that you've been retained as a rebuttal witness for child custody evaluations, or have any others been through Dallas Family Court Services?
No.
Do you know anything about Dallas Family Court Services and how they advise their evaluators to list their limitations?
No.
And if you could just give me a concise phrasing, how do you believe that the limitation should have been stated as it specifically pertains to the mental health records of the child?
Specifically for the mental health records of the child, I think that Ms. Frendel could have stated, due to not receiving the records of Dr. Chandler, who is providing treatment for the child for a period of time, if those records contain information that suggests that the child was previously reporting problems in the mother's home, such as behavior such as biting him, sleeping in the same bed with him, those kinds of behaviors. If Dr. Chandler's records regarding the child indicated that he was very happy and doing very well with the father and in the father's home the 50% of the time he was there, and that there were concerns with some of the things going on when he had time in the mother's home, then the limitation statement should list that out and say that might result in a different recommendation from this social study expert.
Do you believe whether or not those incidences occurred, despite CPS's ruling them out, is an essential element of further investigation that Ms. Frendel was required to pursue?
Yes, actually I do. Or at least make a very clear limitation statement that makes it clear that if those records, if Dr. Chandler is reporting something very different than what the mother and Dr. Ritchie may be reporting or testifying to, that there could definitely be an issue about the child being coached or not.
Do you know whether or not those records were reviewed by CPS prior to ruling out the incidences?
Oh, that I don't know. That would be unusual. I've never seen CPS investigators get a copy of mental health records. They speak to us. You know, I get interviewed all the time when a child's undergoing when CPS is investigating a situation. And if I make the report, they've got my written report that I put into the Austin, window when I make my reports as a mental health professional. But no CPS investigator has ever asked for any of my records.
If it's determined that CPS communicated with the child's mental health providers or past providers prior to ruling out the allegations, would that alleviate your concerns as to this issue?
Objection, Ford.
No, it would not.
So you believe it's incumbent upon a child custody evaluator to essentially disregard the investigation that CPS conducted and do their own to ensure that it was handled correctly?
No.
Let me ask you this. As a child custody evaluator, do you trust the outcome and resolution by CPS?
Yes.
Do you make a determination about whether it was accurate or not based on your review of the facts?
No.
Do you take it for what it says, that an allegation has been ruled out?
Yes.
So if the complete record, well, strike that. If a complete investigation occurred and that included talking to the mental health providers of a child prior to ruling out an allegation, tell the court why do you believe it would be relevant and you would be incumbent upon you to go beyond that investigation result?
Because a social study or a child custody evaluation is not a CPS investigation. A CPS investigation is looking at alleged abuse or neglect and trying to determine if that occurred in that instance or series of instances that's been reported. CPS investigator is not looking at the functioning of the child, the welfare of parent-child relationships, and not making recommendations in the best interest of the child, similar to what a social study or a child custody expert is doing. When you conduct a child custody evaluation, the mental health records from a mental health provider who has worked directly with the child, you're not just looking to see about specific CPS reports, you're looking at the whole picture of the child. How is the child functioning? Does the child have anxiety? What's the nature of the relationship with the child? And in this case, it would be the father who was present with him, maybe at all of those appointments, maybe at some of those appointments. I don't know, because she didn't look at the records. I didn't get the records. But those records are incredibly important. And that's beyond the CPS investigation of a specific report that's been made in a case. So
I'm sorry, go ahead.
So Dr. Chandler's records are related to the overall health, welfare, and the picture of how the child is functioning, in addition to the father, since the father was also seen by him. They're very relevant when you're conducting a full custody evaluation, in my opinion.
Just to be clear, are you telling the court that the father has not provided you with the records of Dr. Ritchie to review prior to your testimony in this case?
I don't recall looking at Dr. Ritchie's treatment records. However, I may have. If I looked at them, they're in my list.
Well, assuming Dr. Milburn, that I haven't been provided this October report that you speak of, and only one I can rely on is your July 7th report. I am asking you whether or not you reviewed voluminous counseling records of the child.
Let me look, because
Okay.
I can answer that pretty quick for you. And would you like me to just read real quick? Because I can go through the list at least and read off some of these.
I'd appreciate that. Thank you.
You bet. So B&E Center letter dated March 30th, 2021. Hannah House forms filled out by Mr. Cunningham in February of 2020. Dad wrote me a letter. I reviewed that. I've got the FLP Family Center letter dated August 17th, 2021. I have the FLP records for supervised visitation, the polygraph examination of the father conducted on 12/11/19, and the polygraph examination of the father conducted on January 8th, 2020. The forensic mental health assessment of the father by Dr. James Davidson, completed 8/2020. The deposition of Robert Cunningham dated February 21st. Transcript of the testimony of Nikki dated December 17th, 2019. I've got 4 certificates of completion of things by Dad, like Parenting in the Middle, Parallel Parenting Course, Parent Education, Family Stabilization, and Rules for High Conflict Divorce Custody Battles. I have reviewed the stepfather doing a video recording in October 2020 at the supervised visitation facility with the child present. Audio recordings of the father and child's interacting on the phone. The amicus email from 9/23/20. A video recording of Logan at FLP 9/26/20 made by the stepfather. Video recording of Logan at Hannah's house by stepfather on 6/6 visit. 13 phone calls between the father and the child. Again, you know, I saw the custody evaluation report by Jennifer Frendel back from August 8th, 2019. The Dallas Police Department Child Abuse Unit forensic interview notes from July 27, 2017. CPS records. The WFAA news report regarding the Father's Day Out with Child and podcast. The podcast of the child with Ed Tootal Jones. Jennifer Frendel's deposition on December 4th, 2019. And I got you the Hannah House notes for supervised visitation.
Okay.
So that's everything that I saw.
Okay. So the answer would be no, you did not receive the records for the child's counseling sessions.
No, I did not.
Do you think it would be important to review those prior to making any expert recommendations regarding alienation?
I'm not going to make any expert recommendations regarding alienation. I will be offering, if I'm asked, an expert opinion regarding what parental alienation is and whether or not there appears to be some things consistent with this family that I've been shown that could fall into that category.
Do you think that the child's counselor would be suited to make a recommendation similar to that about whether or not she believes parental alienation is occurring in the child's life?
I don't know the child's counselor. Is this Dr. Ritzy?
Correct.
Okay, Dr. Ritzy's been involved in the case for a long time, and I don't know her curriculum vitae. If she has worked with parental alienation, and I suspect she probably has, then I would suspect that she would be able to offer the similar kind of opinion, with a difference being that she has worked directly with the child. So she would have what would be considered more knowledge about the child, with the direct contact with the child.
Sure. And she's better suited to make that recommendation, considering she's now met with all the parties, right?
Objection form.
Yeah, well, and I'm not sure, when you say recommendation, I always have this hesitation, because she should not make a recommendation regarding possession and access to the child. That's limited by law to the child custody evaluator. So that's really Ms. Frendel's role. She could talk more in general, similar to myself, about recommendations that are often made in cases where there is or is not parental alienation, but she would need to be careful, and I try to be very careful, to not make recommendations in a specific case regarding a specific child, even if we're treating them, if our role is not child custody evaluator.
Understood. And I'm not asking that she make recommendations regarding possession, access, or conservatorship. I'm saying she can advise the court on whether or not, having met the child and the parties, parental alienation is occurring by either party.
Yes, she could certainly do that.
Okay. And she would be suited to that given that she has so much information. Is that correct?
Objection form.
Again, not knowing her background, I would say I would assume she would be.
Okay. And if it's determined that she had only had two introductory sessions with the child prior to the conclusion of the child custody evaluation, would you still think that her records would be essential?
Yes.
Okay. Now, moving on, you stated that Ms. Frendel failed to assess the cultural issues impacting the child. You had mentioned earlier that you believe the mother's cultural background is relevant. Can you tell me why you think it is pertinent that she assess cultural issues impacting the child?
Yes. When she makes a conclusion that the father is racist against a certain ethnicity, Vietnamese, then you've got a child who is 50% of that ethnicity. And so having some kind of assessment of that, mentioning that in a report, talking about it as a possible issue, I think is important.
And do you recall who indicated that Mr. Crockett was a racist?
Well, my understanding is it was the mother, and in response to that, I got a list of different ethnic races that father has dated and been with to indicate that he gave me to indicate he is not, and that it's an area that a social study expert should be assessing.
Objection non-responsive after. My understanding is the mother. Do you know whether or not the child, and forgive me, I can't remember if I asked you, do you know if the child made any statements regarding father's racial comments to him?
I don't recall.
Okay. Would it be concerning for you if a child was reporting that the father had made racial statements to the child?
It depends on what the father said. It could be concerning, it might not be concerning.
Can you think of a situation where any parent would make racial statements to the child where that would not be concerning as a child custody evaluator?
Well, I don't know what racial statements were supposedly made. And yeah, I imagine, let's say they're having a Vietnamese soup, you know, a faux soup or something, and dad says, your mom cooks this great. You know, your grandma taught her, y'all are part of Vietnam, it's a great meal and it's wonderful. That would certainly be a statement that involves talking about race and not be a negative racial statement.
Okay, and obviously, Dr. Milburn, I'm focusing on the negative racial statements that have been made to this child. Would it be concerning for you if any parent made negative racial statements to a child about any race?
Well, it would be. I just don't know what those statements were alleged to be in this case.
Objection non-responsive after. It would be. Have you understand there's an amicus attorney in this case, correct?
Yes.
Okay, and has anything been provided to you? Well, strike that. Do you believe it's improper for the amicus attorney to involve themselves in any part of the child custody evaluation process?
No, I wouldn't say that's improper.
Do you consult with the amicus attorney when you're conducting a child custody evaluation and there's an amicus involved?
Yes.
What type of things do you ask the amicus attorney when you're conducting a child custody evaluation and there's an amicus involved?
If the amicus has been involved prior to me being appointed as the child custody evaluator, then the amicus is treated by myself and by my office similar to each attorney, with each of the attorneys that represent the parties, with the exception that the amicus is, I do an interview with the amicus to see if there's any information I'm missing that they want their office to provide to me. And I ask questions if there's any insight that they have, they think I might need to know. You know, an amicus attorney, in my experience all these years, typically does a very good job meeting with the kids, going to the homes, you know, checking out, talking with school teachers. Sometimes the amicus has done an amazing amount of work. And so I do like to hear from that person who is outside of the emotional context of the high conflict custody fight, because that insight as a professional is helpful.
And if an amicus attorney gives you information in the case during the course of your investigation, are you obligated to verify all facts given to you by the amicus as well?
Well, under the Texas Family Code, it says that I must verify all information given to me by an amicus or given to me by anybody that I'm considering relevant or important. So yes, I believe if an amicus attorney gave me information that was going to be a part of or important on my recommendations for the best interest of the child, I believe I'd have an obligation to verify, if I can possibly verify, the information that I've been given.
Do you note the information that comes from an amicus in your child custody evaluation report?
Yes.
And do you specifically state this is the information that you received from the amicus attorney?
Yes, I would. I can't recall a case where an amicus sent me anything directly. So I've never had that happen before, but I do know, similar to a collateral interview, when I interview an amicus, there's always a small paragraph, just like the parent facilitator or parent coordinator, if they're put in there, the court-appointed therapist, whoever it is I'm interviewing, the amicus has a paragraph where I document what it is that they've said to me.
Do you recall where in the child custody evaluation of Dr. Frendel it mentions dad being a racist?
No, not off the top of my head.
Okay. Let me ask you this. How long ago did you last review the child custody evaluation?
That would have been 2019.
Okay. Now, one of the other things that you mentioned were concerning to you, and I'm using this kind of blanketed statement again because that's what I see, is offered opinions without completing each basic element of the evaluation. Do you remember stating that? And when I asked you that question earlier, you gave me this entire list that we've been discussing. So does offered opinions without completing each basic element of the evaluation, is that something other than the list you've given me?
No.
Okay. So you did not cite in your report to specific sections of 107 that you thought were insufficient. Is that right?
I think I cited each specific section.
Okay.
I think as you go through the report, you'll see where I cite the section, the subsection, the number, and then I'll give paragraph form regarding the things that I think were lacking or of concern.
Okay. And I mean, a few of these are duplicates, so I don't want to. You indicated you thought that Ms. Frindle wrote more negative things about father than mother. Is that correct?
Yes.
And you thought that showed an inherent bias. Is that correct?
The difference between the two links of writing appears to show a bias.
And that's just because she had more negative things to say about dad than she did about mom?
Or it could be because she had a bias in favor of mom, so she failed to report negative information that she knew about mom and made sure to cover everything she thought negative about dad.
Sure, but it could also be, Dr. Milburn, that there's just a lot of bad stuff to say about dad and not so much about mom, right?
objection form,
Isn't that right?
It could
objection
be.
form,
I couldn't hear you, Dr. Milburn.
It could be.
Okay. And so have you ever had somebody critique your child custody evaluation?
Many times.
Okay. And you had experts that have been rebuttals to witnesses to your child custody evaluations?
Yes, I have.
And you would agree with me that there's always a difference of opinion about what could or could not have happened differently amongst experts, correct?
That's correct.
Lastly, I want to talk about the Lauriston versus Logan issue. On the list of items that you gave me, you indicated that you felt that Ms. Frindle dismissed the Lauriston versus Logan issue. Is that right?
I don't know about the term dismissed. I don't feel like she gave it much consideration. It is in her report. She did write that Lauriston told her he wanted to be called Lauriston. However, what was missing was an acknowledgement that the child was in both households 50-50. And in the father's household was called Lauriston, and the school officials and the people working with him, interacting with him, were calling him Lauriston at the time. While in the mother's home, she was calling him Logan.
Are you aware that the court ordered that the parents would call them different names in different households?
No, I'm not aware of the court order.
Okay. If you learn that the court had ordered that each parent could call the child whatever name they wanted while they had possession of the child, would that alleviate that concern for you?
It wouldn't alleviate the concern that I have about a child being called by two different names.
Okay. And you would agree with me as an evaluator if the court had put an order in place that you as the evaluator do not have the right to overcome what the court has ordered, right?
That's true, yes.
And are you aware now that the child likes to be called Logan?
objection form,
I'm not aware now of what the child likes to be called. I haven't spoken to the child and I don't have any information on that.
Okay. And again, you haven't received the counseling notes from Dr. Ritzy regarding these subjects. Is that correct?
No.
Okay. Have you ever been threatened as a child custody evaluator during the course of your investigation?
Oh, yes.
And were you threatened by a party or an attorney or other individuals?
Oh, a party. I can't imagine an attorney doing that.
Be surprised. How many times has that occurred?
One huge one stands out where the father wrote a death threat and he didn't sign it. He typed it out, put it under my door in a Collin County case. And I believe Judge Oldner was the judge on the case at the time. And the father basically threatened that if I showed up in court and testified on whatever day it was, I would not see the next day. So it was a case where I withdrew, sent notice to everybody and withdrew. He was charged. It took him forever to get the fingerprint analysis back. He was charged with a 3rd-degree felony, and they had his trial, I believe, in Judge Roach's court, and he was given a deferred adjudication of 7 years, where if he came anywhere on this within a mile of my office building in Plano, or I believe anyone anytime in the city of West Tawakoni, that he would be sent to prison and serve the entire duration of the 7 years. That's my best recollection. It was a pretty scary time.
You should have gotten to prison in the first damn place.
At any rate, how many times has that occurred?
That one occurred. I had someone throw construction materials through my window in the Plano office. I had someone attempt to set fire in the upper part of the Plano office over where my records were held, that we were pretty sure we're trying to destroy some custody records, hence they're held in a secured location now. I think that's pretty much it. I've had one for sure that we identified who, and then 2 other scary kind of behaviors.
And on the 2 that you had scary behaviors, did you continue and fulfill your duty to perform the child custody evaluation?
In those 2, yes, because I couldn't identify who was responsible for that. In the one where he threatened my life, no.
Sure, understood. Have you had a parent threaten you during the course of your child custody evaluation that if you don't act or conduct it in a certain way that they'll report you for your against your license?
Yes.
How many occasions has that occurred?
Generally, I want to say maybe just a couple, because most parents are bright enough to know not to do that when they start the evaluation. It's usually not until we get toward the end of many months and they're starting to suspect or to think it's not going their way, and then they'll make those kinds of threats or those kinds of statements.
How on the 2 occasions
years ago?
I'm sorry.
Sorry.
On the 2 occasions that you just referenced where you can recall that occurred, did that affect the recommendations that you gave in the case?
Both of those cases were at the end, and I don't believe they affected the recommendations that I made. One involved a father who had thrown a Molotov cocktail. The FBI then arrested him shortly after that appointment, and I think he went to the federal pen, so the recommendation didn't change on that one. He had blown up a vehicle, blown up a house or something there in Collin County. And then the other was a child sexual assault case where, as I came to the end and he was making those kinds of statements to me, that was at the time that the criminal courts then took him into custody And I believe child was under 10, so I think he got 20 to life. So those were those two cases that I recall.
And you indicated that
you really have to be pretty unstable.
You would agree with me that it's bad behavior for a parent to threaten the child custody evaluation during the evaluation process. Is that true?
Yes.
And you indicated you reviewed Jennifer Friendle's deposition in this case, correct?
I do recall looking at it.
Okay. And you saw that Mr. Shizo stated or testified that Mr. Crockett has threatened her during the child custody evaluation process.
Objection form.
I don't recall reading that.
But you would agree with me that if Ms. Frindle testified to such threats during her deposition, that could lead to some negative inferences regarding Dad's credibility, right?
Objection form.
What's your objection?
Assumes facts not in evidence and it's argumentative.
You can answer, Dr. Milburn.
I'm not sure. Inferences by who? You mean inferences by Ms. Frindle about Dad?
Yes, ma'am.
Yes. If Ms. Frindle felt that the dad was threatening to file a board complaint against her or sue her or something and made those statements to her, I could see where that could potentially cause Ms. Frindle to have a negative impression of the dad. I think it would actually be human to form that kind of feeling or impression.
Now, you've indicated that there have been some materials that Mr. Crockett has given you over the last, I'm going to say 9 months after your January 7th report, right?
Yes.
And you're aware that those same materials were not provided to Jennifer Frindle, correct?
I don't know what's been provided to her or not.
Well, for example, the recordings that you referenced earlier that you were given by Mr. Crockett, those are recordings that occurred between him and the child. Is that right?
Yes.
And those were recordings that occurred after the child custody evaluation had occurred.
Well, yes, the first one, but my understanding from the father is Ms. Frindle is conducting a current one. So I would hope he provided her with that information in this current one.
But
I'm so sorry, the video is cutting out a little bit.
That's okay. I'll take a minute if you need to catch up.
Okay, you just go, your video goes kind of bland for a little bit and you freeze. So I've heard your question so far, but you may have to repeat yourself at times.
I have bad news.
My connection is not always that great.
Yeah. Okay, can you hear me now, Dr. Milburn?
Yes.
Okay. And if I need to slow down, just yell at me to slow down, or if I need to repeat, just let me know, okay?
Okay.
And I guess my point being is that at least in the child custody evaluation that you reviewed previously, the recordings that you reviewed did not exist, right?
Yes.
The FLP records and the Hannah's house records and these additional records that you've received, those are associated with visits that occurred after the child custody evaluation was completed in 2019, correct?
Yes.
Okay. And your hope, at least what it sounds like, is that these are things that have now been given to Dr. Frindle, so when she does an addendum, they can be included. Is that right?
Yes.
Okay. And now that I understand that you are being designated as an expert in the area of parental alienation, have you formed the basis well, strike that. Have you formed an opinion regarding parental alienation in this case?
Yes.
And do you believe parental alienation is occurring?
I believe that some of mother's behaviors are consistent with what we see with parents who are alienating, and that the outcome of the current relationship between the father and child, where the child is refusing to see the father, doesn't want to speak to the father, in the audio recordings doesn't want to have anything to do with the father, won't tell the father he loves him. Those types of behaviors in the child could be an indication that the child has been alienated from the father.
Do you see father's behaviors that are consistent with parental alienation?
I think that there was potential parental alienation in the first evaluation process up until he was supervised. I haven't seen anything since the supervision or in the recordings of their interactions that seemed like parental alienation to me. He does have a tendency in his phone calls to bring up the past. He will talk about when I'm gonna call him Logan, because that's how he goes by now, I understand, out of respect for him, that he'll talk about like when Logan was a baby, or having Logan's hair saved, or do you remember when you met, I think one of it was a Dallas Cowboy cheerleader, I think probably in a podcast. So dad is bringing up things from the past to the child in, I think, an effort to try and connect with the child and remind the child of past memories. I don't see a reaction from the child that's been necessarily positive to that. And I don't know if the father and child are in therapy together to do some reunification therapy. I think dad told me it was ordered at some point, but that it hasn't started or hasn't occurred yet. And so again, those communications with the father and the child, I don't know if those are problematic. I think the reunification therapist needs to look at those and be working, find out from the child if they're problematic. And I don't think those problem communications, if they are parental alienation. I think dad's just trying to remind the child, hey, I was here from the beginning and I still love you.
Have you reviewed any of the supervision notes from any of the facilities regarding the visits between the father and the child since supervised visits were implemented?
I did.
And have you reviewed all of them or just some of them?
I think I reviewed all from Hannah's house, and I think those were all pretty good. I don't think there was any conflict or issue there.
Do you recall instances in your review of those notes where the father had to be corrected by the supervisors for making alienating statements?
I don't recall those.
Okay. Would you have made note of those had you seen those?
I didn't detail what I saw. I'd have to go back and look at my records. I would have made note of those if I'd seen them, if they had struck me. The conversations in his phone calls struck me, you know, what he was talking about as being a possible area of problem for him. I didn't see things in the supervised visitation notes that struck me as being significantly problematic.
Do you believe it's healthy for a parent to talk to the child about the litigation?
No.
Would that have been something you would have noted had you seen that in the supervised records?
I don't know that I would have noted it in a way, because that's not really, when I looked at it, I was looking to see if there were any huge problems, if they were doing the supervised visits, which they were, and I didn't note it or recall it as being very significant. My experience with Hannah's house and with FLP is that the professionals in both places are pretty awesome. They step in really fast. They do a great job protecting the kids. And they both have been places that I really trusted. Is Hannah's house open still?
No.
Yeah, see, we lost that. It was so sad.
And do you have any experience with B&E facility?
I don't.
Have you ever heard of the B&E Center?
Well, I got it. There's an updated letter from them, and I don't know much about them. There was some center that was providing supervision in another case. It was another Dallas case, and it was out toward Arlington. And they seem to be pretty good too. I just didn't have as much experience with them over the years as Hannah's House and FLP.
Sure. And you're aware that FLP has disengaged this family from services?
I'm aware of that, and I'm aware of why Father believes that that happened.
Okay. And did you review the letter from FLP to see the actual reason that they have disengaged the family?
I don't believe so. I can look though real quick.
What did Father tell you was the reason that FLP disengaged services with the family?
If I recall correctly, I believe he said that the stepfather was recording the exchanges, and in recording when they would arrive, that violates the policy of the supervising center. And I did see the two recordings where the stepfather had the child to go to the visit, where the child told the supervisor he didn't want to go. And in one of those, I saw the stepfather coaching the child. He didn't seem to have remembered what he was going to say. And I saw the stepfather kind of coaching him about what to say to the supervisor to not go.
So
And
just to be, I'm sorry, go ahead.
If a child won't go, it doesn't want to go into the center, the supervising center is not going to force them to do that.
Just to be clear, your testimony is the father has delivered recordings that he purports were recorded by the stepfather. Is that right?
I believe that's right.
Okay, I'm just making sure I heard you right. And do you know how many times a child has to refuse to see their parent at FLP before FLP will disengage services?
No, I do not.
Do you know how many times the child in this case refused to see the father prior to services being disengaged?
I do not recall a specific number.
Are you aware that the father in this case has not visited the child at the B&E Center ever?
No, I'm not aware of anything with the B&E Center.
Would it concern you if there is a court order allowing dad to have access to the child at the B&E Center and he does not accept that access?
Objection, Ford.
Anytime a parent does not accept access to a child is a concern to me.
And is whether a parent is willing to utilize their possession something that you consider when making a recommendation on parental alienation?
Yes.
But yet, as an expert in this case, you haven't been given any information regarding Mr. Crockett's access to the child in the last year as it pertains to B&E Center. Is that correct?
The only thing that I received was a B&E Center letter dated March 30th, 2021.
And that was for what purpose?
I don't recall that letter.
Okay, that's fair enough. you've testified previously that you have become aware that the child no longer even wants to speak to the father. Is that correct?
That's what the child has said on the phone recordings that I heard.
Okay. And these are recordings that the father made between the father and the child. Is that right?
Yes.
Are these audio recordings or are these video recordings?
They're audio recordings with a transcript also. So it as I went through them, he'll have an audio recording and he'll have a transcript of the communication.
Okay. And have you matched up the transcript to the audio recordings to ensure that they're identical in nature?
I reviewed a handful of them and they appear to be identical.
And what was the purpose, if you know, that you were given those recordings?
I think Dad was wanting to provide me with information to support his claim that his relationship with his son is deteriorating outside of his doing anything that would cause that deterioration. So, for example, if the child was talking to him, very engaged, sharing information, and in one phone call in October of 2021, the child tells him, "I love you." Dad says, "I love you back." It's a very positive kind of communication between the two of them. And then by January 18th of 2022, the child says he doesn't love him and he doesn't want to see him and says he doesn't know why. And that kind of continued.
Did you and Mr. Crockett have any communications about how often he physically sees the child?
I believe he had supervision, and my understanding was that there was some contact going on. COVID closed things down and the supervision closed down. I believe the amicus worked to arrange some time, but it sounds like it's been very disjointed, not a regular kind of scheduled contact. And I don't know if the child is having any contact with him at this point.
When was the last time you had a conversation with the father in this case, Mr. Crockett?
On October 21st of 2021.
And do you recall if he indicated to you at that time whether or not he was visiting his child?
I recall him telling me that they were supposed to go to therapy, parental reconciliation, and that he was having phone conversations, and he obviously is, because I've got a copy of some of those recordings. And I don't recall off the top of my head what his contact was at that point.
Okay. Has Mr. Crockett made any representations to you or shared any opinions with you about the amicus attorney in this case?
Not that I recall.
You indicated that the amicus attorney had made efforts to ensure contact between the father and the child. Who gave you that information?
It had to have been the father.
Okay. If you have seen statements by the mother that you think are concerning regarding parental alienation, and if you've reviewed behaviors of the father that you think are concerning regarding parental alienation, is it your plan to come into court and testify that you've seen this on both sides?
Well, I think it's my plan to come into court and testify, answer the questions that y'all ask me.
Right, and if I ask you that question, that's what you're going to tell the court. You've seen it both directions, right?
I'm going to tell the court that I've seen instances on mom's side and in mom's deposition testimony that are suggestive of parental alienation, and that the child's decreasing contact with the father and unwillingness to want to talk to the father based on the child's statements to the father raise the concerns that parental alienation is going on by the mother, and that Ms. Frendel, I saw in her report, had some concerns about father's possible parental alienation, and that could have been occurring prior to the point that this all got brought back up into court.
Objection non-responsive. Just a yes or no. If I ask you the question regarding whether or not you've seen concerning behaviors on both sides, is your answer going to be to the court? Yes.
Yes, I have seen concerning behaviors on both sides.
Okay. And when you have a situation like that, where you have concerning behaviors on both sides, how does that affect the recommendations when you are performing the child custody evaluation?
It depends on what the concerning behaviors are.
In this instance, if the father has refused to visit the child for a year at the B&E Center, would it be important for you to know that so that you can make a fair representation to the court about the reasons the child no longer wants to speak to the father?
Objection form.
It's a terrible question. I'm trying to see if I could clean it up, but
I think I can answer you.
okay.
Yes, and typically the way I get that information is when there's a trial, I prefer them in person than on Zoom. I usually am able to sit there through the course of the testimony. So I'm able to hear that testimony as I'm sitting in the courtroom, which allows me, when I'm on the witness stand as the expert, to be able to answer questions more directly about that, so that the attorney doesn't necessarily have to ask a hypothetical question. They can ask me a question such as, you heard so-and-so testify to this. Based on the knowledge of this, do you have any concerns as an expert? And then I will tell you my concerns.
You understand that Mr. Crockett in this case is the petitioner, right?
Was that the original case? Is it still the same as the very original one all the way back in 2017?
Yes, ma'am. He's still the petitioner. Do you understand that?
Okay, well, I wasn't aware. It's been several years, so, okay.
And so he gets to go first, and he gets to put on his witnesses first. Do you understand that?
Yes.
And so the only thing you're going to get to hear before you testify is what he wants y'all to hear, right? Through his witnesses. Do you understand that?
Yeah, unless you turn around and say, we want her ordered to stay here, Judge, to hear these other witnesses, and then you recall me to ask me, to have me answer questions based on what those witnesses have testified to.
Understood. And I guess my question is would it be helpful for you to have all the information reviewed prior to coming in and giving a testimony about whether or not alienation is occurring in this case?
It's always helpful to review all the information before coming in and testifying. But my experience really has been that attorneys such as yourself, y'all are very good at what y'all do. And so either I'm there in the courtroom and I listen to the testimony, or I'm given information when I'm on the witness stand where I'm able to respond to that.
Okay. And I'm jumping around here because I'm trying to clean up some loose ends, Dr. Milburn, so forgive me. Have you had a situation when you're conducting a child custody evaluation and the parent has, one parent has brought in, or both for that matter, any parent has brought in voluminous information, banker's boxes of information for you to review?
They always do.
And have you had situations where one parent brings in voluminous information and the other parent doesn't?
Yes, I have had those cases.
And in those specific cases, do you still review the volumes of information that one parent provided you?
Yes, I do.
And do you consider that to be unbalanced, given that the other parent only provided you some information?
No.
Why?
Because I also take all of that and I go back to the first parent and tell them what I have and offer them the opportunity to answer for every allegation and every piece of information in all of those banker boxes, if it's relevant.
Does it make a difference to you who is paying the bill when you are conducting a child custody evaluation?
No.
So if you are a private court ordered evaluator and each parent is ordered to pay 50%, do you think that is fair that each parent pay 50% when one parent is providing you 15 hours of work and the other parent is providing you 5 hours of work?
I think that it's the question of fairness. It can't really be asked by me. I think the judge usually orders 50% if both parents can pay. Sometimes the court orders 100% for one parent to pay because they may be extremely wealthy. I've had a lot of cases like that in Dallas where one parent pays for the whole thing. I'm aware my fee structure is not what other experts are. And so I am sometimes shortchanged if I turned around and figured out how many hours of work I put on something and the actual pay. I feel like I'm working for less than what you get paid at McDonald's when they bring me in 4 banker boxes. But I still look through all the material, even if I'm getting paid like a McDonald's cashier, because we're making recommendations in the best interest of children, and these children are important. And the court expert has a lot of weight with the judge. So I look at it all, even if I'm sometimes sad that it's taking me an extraordinary amount of time.
And is it your plan after the addendum comes out to review the addendum of Dr. Frindle and update your report for the court?
That was not my plan. No one has asked me to do that.
Okay.
If we do that, Ms. Hayes, we'll be glad to get it to you promptly.
How long does it generally take you, doctor? And I know that's such a sad word generally, but historically, what's the average amount of time it takes you to complete a child custody evaluation, just a standard child custody evaluation?
4 months.
And do you know how long it took Ms. Frindle to conduct hers in this case?
I don't recall.
Does the time that it takes you to complete a child custody evaluation vary based on the number of cases you're carrying at the time?
Yes.
Meaning back in 2016, when you were, I'm sure, overwhelmed with child custody evaluations, were you still averaging about 4 months?
That was a little closer to 6 months. And I had Dr. Monica Schocken working for me as a forensic staff member. So, and I had an office manager who was working for me. So the cases worked much more quickly because I had staff I was paying. Whereas now it's only me.
I understand. And do you know whether or not Ms. Frindle has any staff to assist her?
I don't know.
Okay. As far as financial status of the parties, do you look, when you're conducting a child custody evaluation, do you look at the financial status of the parents?
Yes.
Do you, if both parents are, middle class or upper middle class, does that affect your child custody evaluation recommendations at all?
No, it's not normally about what the socioeconomic standards are between the households. If I have a family, sometimes though, that has a very wealthy parent on one hand and a parent who is kind of struggling to just meet the child's needs, clothing and stuff, I will sometimes include a recommendation in the evaluation that the very wealthy parent pay for all extracurricular activities, pay for private school. I won't give a number typically regarding child support, but I will generally make some kind of recommendation where a very wealthy parent covers those needs for the child so the child can have the kind of experiences and opportunities when in the mother or the father's home, vice versa.
Do you have any information about the financial status of either of the parties in this case?
I don't have any information about the financial status, but I did look up to make sure they were both employed, and I checked out the employment information of Dad, which was not that hard to do, and he's been around for a long time, and the employment information of Stepdad, which also was not hard to do. He had the pet grooming taken care of place for a long time, boarding, or at least reasonably long, longer than just a few months. So I was able to confirm that both of them were employed and had an opportunity to financially support the child.
Have you indicated earlier to me today that you had one child custody evaluation that extended over many, many years, and you were ordered to give quarterly reports. You
Yes.
recall that testimony?
Yes.
Do you think it was helpful to the court to have updated information given the longevity of the case?
Yes.
Are you aware that this case has been pending for almost 5 years?
Wasn't aware it was 5 years. I hadn't really thought about that, but that's a long time, in my opinion.
And wouldn't you agree that given the fact that the child custody evaluation was last completed in 2019, it's probably appropriate that the court received newer information?
Absolutely.
And I believe you testified that you are under the impression that Ms. Frendel is updating or doing an addendum to her report to update with more fresh information. Is that right?
Yeah. Yes.
Give me just 1 second. Did you do any psychometric testing of father yourself?
No.
Have you reviewed the records of any psychometric testing of father?
I reviewed Dr. Siegel's report that included his report of that, and I reviewed Dr. Davidson's report and the test that he gave.
I'm sorry, do you know who Dr. Davidson is?
Yes.
Had you worked with him before?
I've never worked with him before. I have been asked by 2 different attorneys' offices to review his child custody cases that he did for them and to give them an independent review of how I thought he did.
Okay. And do you know whether or not Dr. Davidson is qualified to perform psychometric testing in this case?
I believe he is. I've seen his CV. I've seen his CV, And I've looked at his background, and I've had the chance to review 2 other child custody evaluations he did. And then in the process of that, just for the record, I let both attorneys' offices know I thought he did a stellar job.
Objection
I couldn't find
non-responsive.
any problem. Okay.
Objection non-responsive after I did. And do you know anything about a McFarlane in this case?
I believe that's the name of the father's therapist.
And do you know anything about his qualifications?
I do not.
And do you know whether there's been any psychometric testing performed on father in the last 2 years?
I don't know when Dr. Davidson did his work. I thought it's more recently than 2 years. Let me see. Well, whenever Dr. Davidson's report came out.
Okay. Are you familiar with the signs and, well, this what to look for in someone with a narcissistic personality disorder?
Yes.
Have you ever noted signs, or I don't want to use the word signs, but clues that this person might have narcissistic personality disorder without having tested them for it?
No.
Never met a person that you thought was a true narcissist, but without having tested them?
Well, I've met people who have narcissistic tendencies without testing them, but I never put that in a court report or in a written statement without having either them being prior diagnosed by someone. So I've got it in some mental health records that they have that diagnosis, or I've got current testing, or I conduct current testing that supports that.
Okay. Is there any degree of bias, in your professional opinion, that is acceptable bias when performing a child custody evaluation?
I think the short answer is no. Now, every custody evaluator is human. And what that means is that sometimes people's personal experiences or backgrounds can cause them to have a bias that they're not conscious about. When that happens, it's important for the court to know that there's a potential bias there so that the judge or the jury can take that into consideration. And I think it's really important when we do these kinds of evaluations that we try not to have a bias.
I mean, obviously that would be ideal under the model standards of child custody evaluations also, but just to clarify, your testimony is that if there's any degree of bias that's apparent in a child custody evaluation, you believe that is a negative thing.
Yes, I do. I believe that it's a negative thing.
And do you believe it renders the child custody evaluation unreliable?
If there are many components to it, not just one, then yes, I think it can render it unreliable.
And how many is many?
Well, I think in Ms. Frendel's case with her first evaluation, there's enough concerns there that my recommendation was that the court not use her recommendation for custody in this case. Now, she's been given an opportunity to update her report. I don't know if she's seen my opinion or not. If she has, it may give her kind of some help in terms of answering some of the questions in this update that I felt like were lacking in her first evaluation. You know, my hope is that the next one is a little more complete.
Understood. Okay, Dr. Milburn, I really appreciate your time today, and I'll pass the witness at this time.
I'll reserve my questions, everybody.
Okay, Dr. Milburn, you have the right to read and sign your deposition. Would you like to read and sign it?
Yes.
And what is your email address that I can send that to?
All right, it's drdonnabone@gmail.com. So DRDONNA, B as in boy, ONE @gmail.com.
Okay, thank you very much. And Thomas, would you like to order a copy of the deposition?
Yes, ma'am.
Okay, I will follow that up with an email confirming that, okay?
Sounds great, y'all. Chris, you about ready to head back to the Bahamas?
Yeah, now would be good.
All right. Y'all take care, ladies.
All right, take care.
Bye.